We're consulting on reforms to certain aspects of commercial leasehold law. This is a focused project which is examining technical issues with two pieces of legislation that stakeholders have told us are causing problems for commercial leasehold transactions. They are the Landlord and Tenant Act 1987 and the Landlord and Tenant Covenants Act 1995. Our proposals aim to make commercial leasehold transactions simpler, clearer, and more efficient. On the 16th of June, we published our consultation paper. It addresses two main issues. First, the right of first refusal for flat owners in the 1987 Act. If the landlord of a block of flats plans to sell part or all of what they own, the 1987 Act sometimes requires the landlord to offer to sell that interest to the flat owners instead. This is known as the right of first refusal. We've been told that this right can operate unexpectedly and inappropriately in mixed-use developments. For example, when a landlord grants a lease of a ground floor shop in a block of flats. This can create delay and complexity in what ought to be a straightforward commercial transaction. We are consulting on changing the law so that the grant of a commercial lease in a mixed-use premises does not trigger the right of first refusal. Our proposal is targeted. It's designed to preserve the core protection that the right of first refusal gives to flat owners, while preventing it from applying to transactions that are unlikely to be of any benefit to them. The second main issue that we're consulting on concerns the 1995 Act. We've been told that some provisions of the Act are adversely impacting commercial leasehold transactions between members of the same group of companies and within a partnership, for example, in the context of assignments and guarantees. So, we are consulting on reforms to allow greater flexibility in specific circumstances while maintaining the 1995 Act's fundamental objective of protecting former tenants and guarantors from ongoing liability after they've sold the lease to someone else. We're keen to receive responses from as many people as possible. That includes landlords, tenants, representative bodies, professionals such as lawyers and surveyors, and academics who have a research interest in this area. We're particularly interested in hearing from residential leaseholders and their representatives, especially on our proposals about the 1987 Act. The responses we receive will provide the evidence we need to develop our final recommendations for reform. It will then be for the government to decide whether to introduce legislation to Parliament to implement our recommendations. The consultation runs for 3 months and closes on the 16th of September 2026. The best way to respond is through the online form available on our website. You can find the full consultation paper there, as well as details of consultation events we'll be holding, also on the website.